Good morning, respected members of the press. This is a text of impending labor crisis in the state. Sometime on about the 16th day of March 2020, the River State Councils of the Nigeria Labour Congress and Trade Union Congress of Nigeria issued a notice of 7 days ultimatum for the commencement of an indefinite strike action in River State by the organized labor. It is clear from the notice of 7 days ultimatum that indefinite strike action was scheduled to commence midnight of Monday, 23rd March 2020. It is important to mention that in issuing the said notice, the organized labor did not comply with the mandatory procedure prescribed in sections 4, 6, and 18, subsection 1 of the Trade Disputes Act, Cap T8, Laws of the Federation of Nigeria, 2004. Consequently, the government of Rivers State, through the Office of the Honorable Attorney General, instituted suit number NICN, that is National Industrial Court of Nigeria, /Port Harcourt, /41/2020, that is Attorney General Rivers State versus Comrade British Itubo JP and 5 others at the National Industrial Court, Port Harcourt Division, by way of originating summons seeking the interpretation of the provisions of the Trade Disputes Act, Cap T8, Laws of the Federation of Nigeria, 2004, and the Trade Unions Act, Cap T14, LFN 2004, in relation to the threatened strike action by the organized labor. The Honorable Attorney General as claimant seeks a number of declaratory and injunctive reliefs against the defendants on record. Given the extreme urgency of that matter, the Attorney General also filed an ex parte application for interim injunction, restraining the defendants in that suit from commencing, embarking on, or proceeding with the strike action pending the hearing of the motion on notice for interlocutory injunction. That ex parte application was taken and heard by the court on the 23rd day of March 2020, and the court, after hearing extensive argument, issued an interim order of injunction against the defendants, restraining them either by themselves or through their servants, agents, privies, officers, or otherwise howsoever called, from embarking on any strike action in River State on 23rd March 2020 or any other date pending the hearing of the motion on notice for interlocutory injunction. The court also restrained the defendants from interfering with the provisions of service and other works by their members in this public and civil service of River State pending the hearing of the motion on notice. By the agreement of the parties, the originating summons in that suit was later heard on the merits by the Honorable Court on Thursday, July 23, 2020, and judgment in that suit has been reserved to Tuesday, September 29, 2020. Surprisingly, while suit number NICN/PH/41/2020 is still pending, and interim order of injunction issued therein is still subsisting, the defendants, acting in collusion and concert with the national leadership of organized labor, that is NLC and TUC, issued another threat of fresh strike action in River State based on the same grounds canvassed in their earlier 7 days notice of ultimatum, and without complying with the mandatory statutory provision prescribed for the declaration of strike action under our law. In the face of that overt, unmitigated illegality, and being a government that is committed to the enthronement of the rule of law, the Office of Attorney General again approached the National Industrial Court, sitting at Lagos, that is as a vacation court, through a new suit, that is suit number NICN/LA/305/2020, that is Attorney General Rivers State against Nigeria Labour Congress and 5 others, seeking the interpretation of the provisions of the Trade Disputes Act and the Trade Union Act in relation to the threatened strike action. The claimant also applied for an order of interim injunction restraining the organized labor from embarking on, proceeding, or taking any action in furtherance of the threatened strike either on the 5th, 6th, 7th, or 8th of September, or any other date, whether earlier or later, pending the hearing of the motion on notice for interlocutory injunction. The trial court, sitting in Lagos, after hearing extensive argument from the Attorney General, granted the interim order of injunction, restraining all the defendants on record, whether by themselves or through their servants, agents, privies, officers, or otherwise howsoever called, from embarking on any strike action in Rivers State on 5th, 6th, 7th September, or any other date, whether earlier or later, pending the hearing of the motion or notice for interlocutory injunction, and or from stopping, hindering, preventing, disrupting, or in any manner whatsoever interfering with the provision of service and other works by their members in Rivers State pending the hearing of the motion or notice. The court also ordered that the order of interim injunction, the originating summons, and other processes filed in that suit be served on the defendants through publication in 2 national newspapers circulating in Nigeria, and thereafter fix the return date for the matter to Tuesday, 8 September 2020. I can confirm that all the defendants on record have been duly served with the enrolled order of interim injunction, and they cannot purport to claim ignorance of it. Indeed, the affidavit of service have been duly filed in the Register of the National Industrial Court, and can also confirm that the orders have been published in 2 national newspapers, namely Vanguard newspapers of Thursday, September 3, 2020, at pages 24 to 30, and Daily Sun newspapers of Thursday, September 3, 2020, at pages 14 to 20. And in law, any matter published in the newspaper is deemed to have constituted notice to the entire world, and knowledge of that publication is imputed to every person, so they cannot claim ignorance of the publication. It is important to mention that in law, once an order is issued by a court, the party against whom the order is issued is legally bound to comply with the terms of the order until same is set aside, and it is not open to that party to disobey the order. The only remedy available to that party is to apply either to that same court to vacate or vary the order, or to appeal against that order to a higher court. It is also not open to that party to determine whether or not the order was validly made. That power appertains to an appellate court, and the appellate court does not share that power with the party against whom the order has been made. In the circumstance, the defendant in suit numbers NICN/Port Harcourt/41/2020 and NICN/LA/305/2020 are bound in law to comply strictly with the terms of the subsisting orders of interim injunction issued by the court, and are bound to refrain from carrying out or purporting to carry out, embark upon, or proceed with the strike actions in Rivers State, whether on the 5th, 6th, 7th, 8th of September, or any earlier or later date. Now, in law, every disobedience of an order of court constitutes contempt of court, and the court that issued that order possesses both statutory and inherent jurisdiction and powers to punish the party in disobedience by committing that party to prison until he purges himself of the contempt. This is a settled principle of Nigerian law. The organized labor, therefore, is warned against any act of overt or subtle disobedience of the subsisting orders of interim injunction issued by the National Industrial Court until we return back to court on 8th of September for the hearing of the motion on notice. We will be moving the Honorable Court on the said 8th of September 2020 to issue Form 48, that is notice of consequence of disobedience to court order against all the defendants on record. And this is a warning to the defendants.